Case P104624 in the matter of Stephen Singer. Counsel, please make your appearances.
Thomas Grover, 12387 on behalf of Black Rock Legal.
Good morning.
Good morning, Your Honor. Laura Deeter, 10562 on behalf of Lenore Boekankamp and Natasha Singer. I believe Lenore is present via Blue Jeans as well.
All right, good morning. Do we have Ms. Singer? Ms. Singer, can you hear me? I can see you. Yeah, you can't hear us. I can see you. We can't hear you. Ms. Singer, would you please call in? You can leave your camera on so we can see you, but if you could take your phone and you could call in, please. Ms. Singer, do you have the number to call in? Can you shake your head? Okay. All right. Wonderful. Thank you. Ms. Singer, we're going to put the number again in the chat just to make sure that you have the right number. So give us a moment, please. Do you have it? Okay, 1408.
And Ted said that she spoke to her as well. This one, I think. Yeah, I'm taking it that one too. Know this number, right?
No, we can't call.
Yeah.
That is not a conference one, we need the
The
standalone
one.
one, yeah.
Mhm.
Let's see if you call next to her.
Like use a microphone, like a cell phone?
No, just leave it on speaker,
Yeah, you know, so you can put it next to your phone.
ask her what's her number.
Let's see if we can look at it.
All right, Ms. Singer, any luck? No luck calling in there? All right,
She heard it.
okay, what we can try to do, it's unusual because we normally don't. We can try to call you and place you on speaker, put the microphone right next to the phone so everyone can hear and so we can record you, okay? We're gonna try that.
It's got some feedback.
Oh, no, okay. Well, if we can't do it, then we can't do it.
Can you hear me? Can you hear me? Can you hear me?
Ooh,
Can you hear me? Can you hear me?
so we can hear you, but there's a lot of echo feedback.
Hold on.
So,
Because she's using the phone and she has blue jeans.
okay. Can you, well, her computer's muted, so it shouldn't, that shouldn't affect it.
How's that?
Okay.
Okay, that is better.
I'm sorry, I had to close the blue jeans out. I tried to call, but every time I would dial the number, it just kept repeating,
Does that
type in the meeting ID and press the pound sign. Even though I was typing it, I apologize.
All right, Ms. Deeter, can
Thank
you
you for your
hear,
patience.
can you hear Ms. Singer when she's speaking like this?
I can hear, can you guys hear me okay?
Was that Ms. Singer?
I can't hear you right now, but
Oh,
can you hear me?
no. We can hear you, you can't hear us?
Just faintly.
Yeah, this isn't gonna work.
Let me try to log into the blue jeans again, but only not do this sound maybe, or not call in, or see if it's going to work. Okay.
Oop,
No.
no, we have the echo again, we can't do it that way. Can you hear us though?
Yes, sorry. Hello?
Yes, can you hear us?
Not really.
Okay, we
I
can't.
can hear you now.
I want to make sure that you can hear and that everyone can hear because we have a lot of things that we're going to discuss. And if you can't hear us, then that's a problem.
Okay, let's try. And if, there's an issue, maybe we can continue until I can, and I'll come in there next time. I apologize. It works all the time. I don't know why it's not working today.
You're not alone.
Thank you.
You don't know how many times we have someone sitting here saying, it worked yesterday. But
Thank you so much.
it is very important that you can hear and that everyone can hear what we're all saying. So
Yes, ma'am.
if you can't, I do not want to continue. Okay, can you hear everything I'm saying?
Yes, ma'am.
Okay, I'm going to ask each counsel now to say something and then just, hi, how are you? Something very simple, and then I'm going to ask if you can hear them. So Ms. Deeter, could you just say, hi, how are you? Or something, whatever you'd like.
Karina, this is Laura Deeter. Can you hear me?
Yes, I can hear you. Thank you.
All right. Mr. Grover, I don't know if you'll be speaking today, but let's just test it
I
out.
will be.
Okay.
Thomas Grover on behalf of BlackRock Legal.
I can hear you. Thank you.
Okay, so at any point in time, if you can't hear any of us, please let us know, stop, type in the chat, and then we'll have to continue, so you can come in.
Okay.
Okay,
Thank you.
so we are here on our two matters that have been consolidated. So I am going to start. My law clerk and I have been reviewing both cases and coming up to speed. There is a lot in the files. So first off, I'd like to make sure that you are filing documents in the appropriate case, so the file remains clear and we're not flip-flopping when we're looking for an opposition to a motion. I understand in the last department it may not have been an issue and you could file wherever you wanted to file. You're now in Department 5, so please make sure you file in the appropriate case. All right? So,
And then is that the lower case number, or which case number are you considering the appropriate case for this proceeding, Your Honor?
it would be, well, in generally, it will be the lower case number.
Okay, thank you
Okay.
so much for clarifying.
All right. So just so you understand that we have been bringing ourselves up to your case, I just want to briefly state your positions in general, and I know there's a lot more that's gone on. But Ms. Singer, you maintain that the objectors have exercised undue influence, inappropriate control over decedent during his life and are not properly providing accountings, etc. Is that generally accurate?
Yes, ma'am.
Okay. And then, Ms. Deeter, your clients maintain that they are providing the accountings, doing what they need to be doing, and of course that they did not exercise undue influence and inappropriate control. Is that generally your client's position?
Yes, Your Honor.
Okay, thank you. So my next question, Ms. Deeter, you may answer this. There was not a trial in this case, correct?
That's correct.
Okay, thank you. So it's my understanding that there are many matters that are outstanding and decisions that have not been made, approvals that have not been completed
That is correct.
before the matter went up to the Nevada Supreme Court. So that's correct, yes?
There's a lot of issues, and that there are a lot of them that have not been heard, yes.
Yes.
As far as the Supreme Court part, I didn't hear what you said about that. Can you repeat that part?
Sure, there are some outstanding matters and decisions that were not made before it went up to the Nevada Supreme Court, and I'm going to read that list. So I just want to make sure we're all on the same page that we do have outstanding things, yes?
Yes, but the appeal actually was filed by somebody else without my knowledge or request or permission, and they filed a random pleading that I had made for something else. And so the Supreme Court dismissed the appeal because it was some random pleading that I had filed and not at all an appeal that I would have filed.
Okay, so I understand that, but what I'm saying is we have some things that are outstanding. I'm going to read that list, and you tell me.
Got you.
And counsels, you can let me know that if these things are still outstanding, meaning they had not been decided by Department 8's judge before coming over to this department. So the first thing I
Gotcha.
have is the first account and report of co-trustees and related supplements filed on April 2nd, 2021 and August 18th, 2021 by the objectors. Is that still outstanding? Or?
Yes.
Okay. The next
Yes.
I have, yes, thank you, Ms. Deeter. The next I have is the final account and petition for attorney's fees and costs filed on December 20th, 21, and the associated supplement filed October 25th, 2022 by the objectors. Is that correct? Still outstanding?
Yes, Your Honor.
Okay. The next I have
Yeah.
is the petition for attorney's fees and costs filed on October 25th, 2022 by the objectors. Is that still outstanding?
Yes, Your Honor.
Yes, sorry, I was going to let Ms. Deeter answer for her own motions, and
Okay.
then, yeah, go ahead.
Thank you, that's valid. The next would be the petition to approve accounting from October 1, 2015 through February 5th, 2021. That would be filed by the petitioner. Ms. Singer, is that still outstanding?
Yes, ma'am.
Okay. The next is the petition to approve the trustee's second accounting from October 2015 through October 2021, and the petition for attorney's fees and petition for approval of disbursements filed on April 21st, 2022 by the petitioner. Ms. Singer, is that still outstanding?
Yes, ma'am.
Okay. Only two more. The next is the objection of the order from the hearing on June 26, 2022, filed on September 2nd, 2022 by the petitioner. Is that still outstanding, Ms. Singer?
Yes, ma'am.
And our last would be, this is a long title, It was filed by the petitioner on October 12th, 2022. The petition to approve the final accounting, including expenses, items, and costs for both parties from October 1st, 2015 through October 26th, 2022. And the reply to the opposition from the objection of the order from the hearing on June 26, 2022, and a brief case summary of events leading up to now. For the court's convenience, additional evidence providing Karina's allegations against Lenore and Natasha, including elder abuse and exploitation. Is that still outstanding?
Yes, ma'am.
Okay, thank you. So I've noted that on those 7 matters that are outstanding, the parties have fully briefed those matters. So my question, we need to bring your case up to speed. We need to get everything moving forward. So my question is, on these 7, do you want another hearing and oral argument on these issues, or to save time and finances, would you like me to make the decision in chamber based upon your pleadings that you filed and your past oral arguments, and I can go back and watch the proceedings on video so I can have everything? I do prefer to do the latter because you've already argued, you've already filed pleadings. I don't really want to make you do double the work, but I will ask both of your preferences.
Can I just add that there is also the motion to enforce the court orders and a motion to show cause regarding contempt that has not been heard. Well, it was, I guess, kind of heard, but she first said that she was going to take it under advisement. Then she said she was going to defer the ruling, but then it never got brought up again or addressed. And I feel like that needs to be along with those documents or pleadings as well.
All right, so Ms. Singer, can you repeat what those 2 titles are again, please? Motion to show cause.
Yep, notice of motion and motion for an order to enforce court orders and for an order to show cause regarding contempt. And then those 2.
Okay, do you know when they were filed or heard?
Yes, let me grab that for you.
Thank you.
It was filed in May of 2022 because it was for the hearing on June 15th, but I can give you the exact docket number if you give me just 1 second.
Perfect, thank you.
It was docket number 59, filed on May 26th, 2022 in 104624.
All right, and both of them would be under docket 59?
No, in the other case, it would be under, I'm not sure if I filed it in the other case. I might have, but let me just look really quick. I think it's, no, I don't think I did file it in the other case. And then the last one, I apologize if you're ready for me.
Sure.
Is the important supplemental exhibits, the exhibits proving elder abuse.
Okay. Was that not filed on October 12th, 2022? Is there a supplement to that?
September 2nd, 22, document number 76 in 104624.
Okay, so there's supplemental documents regarding your allegation of proof of elder abuse, yes?
Correct.
Okay.
Yes, because I was told that there was no evidence of elder abuse, so I wanted to make sure that the court had that.
Okay. All right, so then we do have, it
Your
looks like...
Honor, I believe those were addressed in there's an order filed September 1st, 2022 in the 105009 case. I believe that addressed the motion for contempt, and there was a motion to strike unlawful order.
Okay.
Frankly, if the court would be inclined to look at that. I don't have Ms. Singer's documents up, but I believe that order was what addressed the contempt motion.
Okay, thank you. So that's what I said, we're going to be talking about a lot of things today. We're trying to get on board so we can kind of clear up the record and we can have decisions on some of these things that have been outstanding for quite some time. So thank you for that, Ms. Deeter. I will look into that and see if that issue was resolved with that order or if it's still outstanding. So thank you very much. So then my question to you counsels and Ms. Singer, do we want to move forward and have the court make decisions on these outstanding issues based upon what you've already filed and what you've already argued? Would that be acceptable?
We would be in agreement.
Sorry, go ahead, Ms. Deeter.
We would be in agreement. Certainly, I'll let Ms. Singer speak.
Okay.
I would love to be able to say, yes, that's great. You know, you'll be able to read through it all, no problem. But I feel like, I don't know, I'm nervous that, like, you know, if something isn't clear or, you know, you have questions or concerns or, you know, maybe you just, I don't know, I feel like the way that information is just presented in this proceeding, that it is unclear and contradictive, and I just want to make sure that all of the information and, you know, and the facts are being presented properly.
Okay, I understand that. So what I will say to you for that is you've put your facts and your information in your pleadings, and then you have argued that in front of the court. So I do feel that I can get a sense of what each side is arguing. I can get your argument and facts. If I have any issues and I feel that I need more, then I will absolutely hold a hearing on it. Is that fair?
Okay.
Okay.
But then will I still have are you just going to put out an order without a hearing at all after this?
So hold on, let's let Mr. Grover speak.
Oh, sorry, go ahead.
Sure. I don't have a position on any of the outstanding briefing that you mentioned. Our office previously represented Ms. Singer in her capacity as a co-trustee. We've been out of this case now for a year and a half, and we asserted an attorney lien about 14 months ago. And Ms. Singer and Ms. Deeter can correct me if I'm wrong, but I don't believe anybody opposes payment of my fees. I would like to not, I love everybody here, and I like hanging out with everybody, but I'd like to stop coming to these hearings. And so I would ask today that my fees be approved. If the court's not comfortable with ordering payment of those until you've gone through the motions, that's fine, but I would like to not keep spending time on this.
Okay. So this will be the first question then, and I will first put that to Ms. Singer. Is there any opposition to Mr. Grover's approval and payment of fees at this point in time?
I mean, I would like to get Mr. Grover paid as well. My position was going to be that the majority trustees, the defendants, or the objectors, I should say, are the ones that should be paying his fees, and those fees should not come from the trust, simply because we should not have even had to go through a hearing. Everything was properly funded in the trust. All of the paperwork was put together correctly, and somehow we've still gone through 2.5 years of a proceeding and have no answers yet. And so I feel strongly that they should pay that. But if you know in your mind absolutely that you're not going to approve that, Your Honor, then let Mr. Grover get paid out of the trust.
Okay. Well,
I don't want to hold up anybody's money, but I just want to, make sure that all my options are open to me.
okay. My question is, do you oppose the court right now approving and ordering payment of the fees for Mr. Grover? So it's okay if you say yes, it's okay if you say no.
You mean from the trust, or just in general that he should get payment?
Well, I'm asking from the trust.
From the trust, because the trust has the funds.
And my suggestion would be that I can put in the order that you reserve how to allocate those later. Because that sounds like what Ms. Singer is concerned about. So we would get paid, and then the court can make a decision later about how to allocate those among the trustees and beneficiaries.
And that's why I'm asking if there's an agreement. If there's an agreement, then yes, I'll absolutely go ahead and order that. But this issue, Mr. Grover, is not in front of me right now. So I don't know how much your fees are. I don't know anything surrounding that. That's what I'm saying. If there's an agreement between Ms. Singer and Ms. Deeter that they're willing to approve, they're not opposing, and give payment from the trust right now, but as Mr. Grover stated, there could be wording in the order saying if at another time the court orders contribution from a different party, then that can be made. But I don't have this in front of me right now, that's why it has to be 100% agreement between all parties. If it's not, then we're gonna move forward on a different way. So I'm not pressuring anyone into deciding anything, but if you feel that Mr. Grover's should be paid and his fees are appropriate and reasonable, and you want to do that right now, we can go ahead and take care of that right now.
And I'll note for the record, the fees come from a lien that we asserted in February of 2022. That's filed with the court. It has a Brunzell analysis and our invoices. So everybody's had these, and they are $33,000, $365.03.
Thank you. All right. So, Ms. Deeter, I'll ask you, do you have any objection to that at this point in time?
We did not file an objection to the lien or the fees. I think it was one of the matters that, frankly, was shoved down the road. I think the court had wanted the Brunzell analysis, which Mr. Grover had also filed a limited objection on October 18th, 2022. I think the court gives the trust gives very broad authority for fees, hence we did not object. I would request, as Mr. Grover suggested, potential offsetting language, that if there should be an offset for fees, that be determined with the final accounting issues, and I believe that was briefed in the pleadings as well.
Okay.
But no, we have not objected to the fees themselves.
All right, thank you. So then you would be in agreement to approve release the funds with the offset language?
Correct.
Okay. So back to you, Ms. Singer, what is your position on that? Would you like to do the same? Do you understand? Do you have questions?
Let me just make sure. So, to be clear, we're going to pay Mr. Grover now so that he doesn't have to keep showing up in the case and filing liens and stuff like that. And then if there is a decision later on down the road, or the court finds it, acceptable or warranted for the objectors to pay for those attorney fees, then those will be reimbursed back to the trust for distribution, how the court decides. Is that correct?
Yes, and it could go the other way as well.
Right.
Just so you're understanding.
Understood. Okay, so I think yes, let's pay Mr. Grover his fees, and again, if there's a decision later on, either way, for either way, that those fees would be reimbursed to the trust and then redistributed into equal thirds as the trust allows or demands.
Okay, there will be language that does say something to that effect that you'll put in there, Mr. Grover. And or the court could find that it was proper that the fees were paid by the trust. So those are the three different options, just so you understand. Again,
thank you.
This is not in front of me today. I understand your reasons for asking,
Sure.
but as long as all three of you are in agreement, which all three of you are in agreement to do so, then Mr. Grover, your liens from February of 2022 in the amount of $33,365.03 are approved, and payment of the fees is ordered. Currently, payment of the fees by the trust is ordered, but please do include language in the order, and it should be a stipulation. Make sure we put words that they were stipulated to.
Sure.
That there will be some offset language that if the court does determine in the future that either of the parties should pay more, pay all, that will be dealt with at that time, or the trust will maintain the payment. Okay, so Mr. Grover, you're going to prepare that, and you're going to circulate that to, well, it's a stipulation on the record, so you can just
do an order.
do an order, but please put in the word.
And Your Honor,
parties agree. Yes, Ms. Deeter.
if we can just include in that, the funds are held in our client trust account. If we can just include specific authority that we're allowed to release the funds to pay from our client trust account, then we'll issue the funds to Mr. Grover's office.
Okay, yes, that has been agreed upon, so that would be appropriate if you could put that wording in, Mr. Grover.
I will, Your Honor.
Okay, all right, thank you. So then, Mr. Grover, you can either stay or you can
Thank
go.
you,
I
Mr.
don't think
Grover.
you have any other issue.
Thanks, Ms. Singer. Thanks, Ms. Deeter. Thanks to the court as well. Don't be offended, but I am going to leave.
We are not offended. We completely understand.
Okay.
All right, thank you, sir. Appreciate your time. All right, Ms. Singer and Ms. Deeter, so let's move forward. So I think it's been determined that the court will make a decision in chambers by reviewing what you have already filed and by reviewing the hearings that you had. So we'll watch the video, we'll listen to your oral arguments. So the court will make decisions on those outstanding things. The other two issues that Ms. Singer brought up, well, three, the supplement and the notice of motion to enforce and show cause regarding contempt, the court will look to see if it was resolved in an order or if it's still outstanding, okay? If I do have questions and I don't feel that there's enough information, I will set a hearing for you to come in regarding whatever motion, whatever outstanding issue, just to talk about that. But if I feel that there's enough, then I will just issue an order that you will receive, okay?
You know what, Your Honor? I did not really orally argue in court because I assumed that the court was reading the documents. And so I feel like, I was not able to give an oral argument like I would have had I realized that that's what you're supposed to do. I just assumed that the court would read the documents, we would come in, the court would address their concerns, and then I would speak to them. But the court left out so many concerns that I feel like I was not able to orally argue those. And so, I know you said you're going to rely on my oral argument, but I just don't feel like that's going to be sufficient.
Okay. So here's what I normally do. Your pleadings are what you file and you present to the court, and that's your argument. And sometimes the court just reads the pleadings and makes a written decision. Other times we do have hearings where the parties will come in or be present on Blue Jeans, and then, excuse me, and then they will point out any additional information. Well, everything should be contained in your pleading. So then they'll just highlight anything that they feel is important. Usually, I will not have you reiterate the whole thing. I won't have you reread your pleading in front of the court. It will be just anything that you feel is important to point out in a short and expedited basis. So if you want to have hearings on these things, then we can absolutely do so. It will be very quickly. We will have about probably less than 5 minutes to speak back and forth. Sometimes I'll have questions, sometimes I won't have questions. So it's whatever you want to do. I don't really want to waste your time anymore because you did file everything. But if you'd like to have hearings on these 7 issues based upon what you've already filed in an expedited hearing manner, we can absolutely do that.
Yeah, you know what? Because we never had an evidentiary hearing or discovery.
You're not going to have evidentiary.
In this contested matter. I'm sorry.
Sorry, you're not going to have an evidentiary hearing about these things. These things are already outstanding. So really, the judge should have made decisions on these because she had all the information. She didn't.
But it's contested, and so it says that we can ask for a discovery or an evidentiary hearing or both and get depositions because I want to make sure that everything is covered.
No, I understand,
I
ma'am.
was told to have a complete record.
Wait, Ms. Singer.
I'm sorry?
I understand. But these things, we're not going backwards. These have to be decided. So we're not going backwards. You're not filing supplements. You're not filing new things in this case on these 7 things that have been sitting outstanding and should have been decided. So if you want to have a hearing, we can have a hearing on that. But it will be what you've already filed in this case, your motion, the opposition, the reply, whatever you've already filed is what I am looking at. And I'll go back and look and see if you did have oral arguments or not. But we're not bringing everything new up in these 7. There's plenty of going forward from here if there's a reason to bring new things up. But these 7 things, they're going to be determined on what you've already filed. And if you want a short hearing on these things because you feel like there's something more that you're going to convey in a different way than how you wrote it, we can absolutely do that. But we're not going to have an evidentiary hearing on these 7 things. We're not, unless I find that there's a reason to. But we're not going from there. We need to go backwards, clean up the case, get these decisions made, and then move forward. So how do you want to proceed? Do you want me just to decide based upon... I think
we should have a hearing, actually. Okay. And because I feel like the orders that are already in, like there's missing orders completely. There's orders that, have been put in incorrectly. And I feel like, those need to be looked at.
Okay, well,
And the evidence has already been submitted. I don't want to submit any new evidence or bring up any things. I have everything submitted, but, you know, some things have been sealed incorrectly. Like some motions have been stricken from the record, I believe, incorrectly. I feel like
then you need to bring a motion.
when you look at these.
No, sorry, ma'am. I don't want to take a lot of people's time. I'm just really trying to make this our first meeting so we understand where we're going from here. So if you feel that there were things that were done improperly, things were sealed and they shouldn't have been sealed, I don't have that in front of me right now. I will not look at that on these 7 issues that we have to discuss. When we discuss these 7 issues, therefore these 7 issues. So if there are other issues where you say, there's another issue, then you need to bring a motion for reconsideration. You need to bring something to the court to address that specific issue. Well, these are the 7. These are the 7 that I have in front of me.
Okay, I'll file another one then. No problem.
Okay, so if there is something that you feel that was not done or done improperly, then I would, just for ease of reading it, ask that you be succinct and file a motion for each different thing, if that makes sense. Not just the whole kitchen sink, because it's a lot easier for when we go back and when we look at things, if we can keep it just very streamlined and I know what you're asking for, okay?
No problem.
Okay.
Can I give you an example and then you can, let me know if you want a new motion for it or if it's appropriate to add with what we're doing now?
Well, it will not be appropriate to add because, like I said, the 7...
I'll do another motion, Your Honor, no problem.
Thank you, because
Thank you.
I'm just trying to convey that the 7 things that have already been argued and addressed and potentially should have had an order done, that's what we need to deal with. So I don't want to add anything to those things. So if you do have a different motion that you need to take care of, then that would be, yes, you'd be bringing a different motion, okay?
Okay. I believe it's included in one of those motions, so I think we'll be okay. I would like to have a small hearing, a short hearing, whatever you call it. I don't want to be a, pain in the butt or, be one of those people, but I just, I would feel more comfortable even with just a short hearing after you've had a time to review everything.
All right, absolutely, and that's why I asked how, some people are comfortable with it being on the pleadings and reviewing. All right, so I think we've addressed everything. So you had asked Ms. Singer for a new trial. So a trial wasn't held. So I think what we are doing by us going backwards and getting these 7 or possibly 9 issues resolved will resolve your issue right now because there wasn't a trial. So the court can't give you a remedy for a new trial, if that makes sense. And then you've also moved today for a default judgment or summary judgment. And so you understand both of those things are not proper at this time. So a default judgment is sought if the other party fails to participate in the case or doesn't file an answer or another motion. Here, the other party has participated in this case, and you've been in this case for quite a long time. So that your request for default judgment,
go ahead.
Yeah, your request for a default judgment can't be granted. Your request for a summary judgment, that also would not be proper at this time because a summary judgment is granted if there are no genuine issues of material fact present. Clearly, there are fact issues present.
Okay.
So I know all of you have been living in this for a long time and you're asking for a lot of things to be done all at the same time. So what I'm trying to do is unwind, figure out what we need to do to get these 7 or 9 things order filed, and then move forward from there. And I think that would rectify, hopefully, a lot of what we have going on. And it might not, but at least we're going to go back and get these orders on file so we can move forward. So if you feel that these weren't right after I make the decisions, then you can move forward based upon that, okay?
Okay. My petition for probate was never actually heard or put on calendar either, just FYI, just saying. And I just wanted to clarify one last thing. I thought that default judgment was the same as approving the unopposed motion. Are you saying that those are not the same thing?
Well, they're two different they're two different things.
Okay, so I was really asking to approve the unopposed motions, which my second, third, fourth accounting had been, no objection had been filed for those, and it had been over 90 days.
Second, third, and fourth. Are those one of the 7 that we have outstanding?
Yes,
Okay.
yes, they all 3 are there. The
Okay.
second accounting, the third accounting, which includes the HEMS for all parties, and then the big long title, the trustees, all that huge long title, that's the fourth one.
Okay, all right, thank you. So then I'll ask, Ms. Deeter, did your client intend to oppose the second, third, and fourth accounting? Or?
Your Honor, I believe we've opposed all of them.
Okay.
I know we've done several omnibus responses due to the volume of filings. We had reincorporated previous allegations, and I believe everything has been opposed, yes.
Okay.
Can you give us the docket number or the date that those were filed?
Hold on,
I
Ms.
have not
Singer.
seen any objections.
Hold on, Ms.
Sorry.
Singer. We can't talk over each other because the recorder can't
Sorry.
take down what we're saying. So go ahead, Ms. Deeter.
I believe there may be some confusion because of the case numbers. What had originally happened is I believe it was the lower case number was Ms. Singer's, one of them was Ms. Singer's petition to open probate. The second was my client petition for a Hegstead petition to fund the house into probate, which was a trust
Which was
case.
denied.
Court had eventually directed that everything should be filed in the trust case, which I believe was the higher case number, hence the confusion back and forth. But I believe between both case numbers, and certainly at this point, everything has been consolidated.
All right, thank you very much. I think that is the procedure, but what is everything filed in right now? So do we want to just keep the lower case number from here on?
I think it makes sense as long as we're all on the same page. We just do the lower case number.
Okay. All right, thank you. So let's do this from here on out, because it is, I believe, the proper procedure to use the lower number. So from here all out, the appropriate case to file things in, unless it should be in the other case, would be the lower number, the 105009 case, okay? So then...
No, that's the higher number. The lower number is the 104624 case.
Okay. Sorry, I have it flipped on my notes. Okay,
That's
so
okay.
The 4264 is the lower case.
It's confusing.
Okay, so thank you. Let's go backwards. So the lower case number is a 104624 case. Let's file everything in that case unless it should be specifically in the 009 case, okay? So then we can say...
Specifically in the what? I'm sorry, what was the last part you said?
Unless it should be specifically in the other case, which...
Oh, well, yeah.
Yeah,
You'll
I
see
can't...
that once you go through the document that there's nothing in that other case.
Right. I can't think of that. So let's file everything in the 624 case, so then we can refer to the right docket number. We can see in order what's been filed, and we can kind of clear up the file and move forward. Okay.
So are you giving them an extension of time to file those 3 objections, or because they said they've already filed them in the other case, it should be very easy for them just to, take them from the other case and move them over to the 104624? Can we get a deadline for those to be filed, Your Honor?
So, Ms. Deeter, you do believe that they've been filed in one of the cases?
I believe it's been filed, yes. Certainly, I need some time to go through the docket if the court wants us to address those more specifically.
Okay.
And how
But I
much time
believe
is she,
everything
so we can have a
is there.
deadline on that?
Okay.
And if
it's
she
already...
hasn't indeed filed those objections, will you consider approving those unopposed motions then?
Hold on. If it's already been filed, I don't want to make anyone do any extra work. So if it's
It has
already
not
been...
already been filed.
Okay, Ms. Deeter is saying it's already been filed. So if it already, and we'll go through the file again to look for that. If it's already been filed, you do not have to refile it, Ms. Deeter, okay? If you feel that you want to keep just everything clear, then you can go ahead and you can file it in the 4624 if it's already been filed. But if it has not already been filed somewhere, I do not want you are not to now oppose and create something and then file it, okay?
Understood.
Okay. So,
Thank you.
what we're going to do is, we're gonna pick a hearing date. Do we wanna do that right now? Okay, okay, okay. So, I'm just speaking, with my law clerk, we're trying to pick a date. Do you prefer we give you a date right now, or do you want us to send you a notice? Because, as he's pointed out, there's 300 filings. I mean, it's going to take a little time. We're not going
I'm
to
okay with
next
you
week.
giving a notice when you're ready.
Okay.
I understand that you need time to review those. Thank you so much for doing that.
Okay, Ms. Deeter, are you fine with us giving the hearing date? And if it
Yes.
doesn't work with your calendar, then of course, you both can contact us
Reach-
and we can switch it. Okay, that makes it easier for us because then we're not sitting here where everyone's watching us, looking at the calendar and trying to find a special setting for you. Okay, so I do think that we have addressed everything. So just for the record, the motion for a new trial and motion for default judgment or summary judgment, as it's written right now, shall be denied without prejudice. I will reserve the right to look at those 7 or 9 issues, and if it does deal with the request of Ms. Singer of the non-opposition, the court will reserve the right to change the, for lack of better terms, the default judgment, which would be a non-opposition decision. So the court will draft a quick order on this in our next steps, okay?
Yes, thank you so much.
Ms. Singer, do you intend to be here in person when we have our hearing?
I would love to be there in person if that's okay with your court, Your Honor.
Well, you can choose. Anyone can be in court if they'd like, or they can be on Blue Jeans. I was just wondering if it was your intent.
Yeah, I prefer to be in court, but if I could get a Blue Jeans notice just in case. I have a daughter. Sometimes things come up.
Okay. All right, so we
Thank
will
you.
issue our notice of a hearing, and again, if anything comes up with those dates and we need to move that because of your schedules, we can do that. Otherwise, we're going to move forward. We're going to get decisions on these outstanding issues, and we're going to move forward. Okay?
Thank you so much, Your Honor. I really appreciate everything and your time today.
All right. Thank you very much, Ms. Singer. Thank you very much, Ms. Deeter. Hope you both have a good rest
Thank
of your
you.
day, okay?
You too. Thank you.
Thank you.
Moving to page